Hi, my name's Bill Johnson. I am one of the heads of the litigation department in Moore Ingram Johnson Steele. I practice in all areas of insurance defense, personal injury defense, but a great deal of my practice involves product liability claims. Any of you who are slightly interested in this video understand the difficulties involved with product liability claims, and that is strict liability. Now, the specifics of how different courts interpret strict liability vary, but there are quite a few general principles which are consistent. Given that, I want this discussion to focus more on how to defend your product rather than discuss the law in various states. I've been fortunate enough to have been selected to defend products which are the subject of product liability claims all over the United States. And while each state has their variances, there's a couple of things that are clear. You must get to know your product and understand your product to defend it. Product liability suits are a special breed of litigation. For the most part, other liability suits are consistent and only vary with the facts. Product liability suits, however, vary with the product and the experts. You will find that products are often attacked by the exact same experts. Do your homework. Look at their prior testimony. Use that to your advantage. For instance, there was one product which I have defended on several cases where the expert said that my product was much safer than a similar but different product. I asked him about that. It drew an immediate objection because of the much. The expert turned to his attorney and said, "I think he's quoting me." And as far as I know, that's the last time that expert has testified against that product. Learn your product. How was it designed? Why was it designed? What are the advantages of your product? How much does it exceed the standards of your particular product? Plaintiff's case always relies on two factors to try to get a jury to give you an award. It's based on a product defect, quote unquote, and they always say it could be safer. And jury, you have to protect yourself, your family, the community from these manufacturers who don't care about safety. Many people call that the reptile theory. It's your job as defense counsel to bring it back to common sense. You explain that when you look at simply one element of a product, you're violating engineering standards and also common sense. For instance, cars could be safer in crashes. If you wanted to build them like Abrams tanks, no one would ever probably get hurt. But if you look at the total use, you start to look at gas mileage, comfort, etc., then a car is a better product than an Abrams tank for their purpose. That's something that you have to explain to the jury. You must look at the entirety of the product, and that's required by common sense, but also engineering principles. To be able to do that with the jury, you have to understand your product and the positives that it brings to the situation. Another similar example occurred in World War I. U.S. Army issued new metal helmets to their soldiers. And what they found was suddenly the amount of concussions went up dramatically. Unfortunately, they said there must be something wrong with the product. As they reviewed it further, they found out that while concussions went up, kill shots went down. So when you looked at the entire results of the product, it saved thousands of lives, and it was a better product overall. These are simple illustrations, but it's your job as defense counsel to make the jury see the entire picture. Educate them, get them to use their common sense, and look at your product as a whole and explain why your product's better than the alternatives.